At the conclusion of this lecture, you will be able to recognize the nature and legal control over bribery, recognize the nature and legal control over fraudulent and wrongful trading. We will discuss potential criminal activity in the operation, management, and liquidation of companies. The Bribery Act of 2010 was introduced to update and enhance UK law on bribery, including foreign bribery, in order to address better international requirements. It is among the strictest legislation internationally on bribery. The Bribery Act creates 4 prime offences: 2 general offences covering the offering, promising or giving of an advantage and requesting, agreeing to receive or accepting of an advantage; a discrete offence of bribery of a foreign public official per Section 6, and a new offence of failure by a commercial organisation to prevent a bribe being paid to obtain or retain business or a business advantage per under Section 7. It is a defence for an organisation to prove that despite a particular case of bribery, it nevertheless had adequate procedures in place to prevent persons associated with it from bribing. Under Section 7, corporate offence is committed irrespective of whether the acts or omissions which form part of the offence take place in the United Kingdom or elsewhere. Section 7 is headed Failure of Commercial Organisations to Prevent Bribery. Therefore, if an employee, agent, or subsidiary performing services for the company pays a bribe, the company is liable unless it has adequate procedures in place to prevent this from happening. Section 9 of the Act requires the Secretary of State to publish guidance containing procedures which commercial organisations can put in place to prevent bribery. This has already been published in 2010. The Act has raised the maximum sentence for bribery committed by an individual from 7 to 10 years of imprisonment. The maximum punishment for a corporate body offence is an unlimited fine. Companies operating in the US must recognize that although their anti-bribery program may be compliant with the US Foreign Corrupt Practices Act of 1977, this does not ensure that it constitutes adequate procedures under the Bribery Act. Therefore, it is up to the individual company to ensure it is in compliance with both of these acts if it operates in both jurisdictions. Fraudulent trading by a company is outlawed by Section 993 of the Companies Act 2006, and fraudulent trading by an unincorporated business has an equivalent offence provision in Section 9 of the Fraud Act 2006. Section 993. The Companies Act provides if any business of a company is carried on with intent to defraud creditors of the company or creditors of any other person, or for any fraudulent purpose, every person who is knowingly a party to the carrying on of the business in that manner commits an offence. It also provides that this section applies to a business which is carried on, A, by a person who is outside the reach of Section 993 of the Companies Act, offence of fraudulent trading, and B, with the intent to defraud creditors of any person or for any other fraudulent purpose. Fraudulent trading is therefore where a company carries on a business with the intention of defrauding creditors or for any fraudulent purposes. This applies whether the company is trading, has ceased trading, or is in the process of being wound up. A conviction of fraudulent trading is much more difficult to obtain because of what is known as the burden of proof as beyond reasonable doubt. If it can be proven that directors knowingly and with malice carried on business affairs with no intent to pay their debts, then the court may find them guilty of fraudulent trading. During the process of winding up and liquidating assets, A liquidator may report their findings of wrongful trading to the court long before they would accuse the directors of fraudulent trading. Evidence must be weighed heavily before the court would even consider such an order. Wrongful trading is defined under Section 214 of the Insolvency Act of 1986 and is the less serious offence than fraudulent trading. Wrongful trading applies when the company has gone into insolvent liquidation. At some time before the commencement of the winding up of the company, that person knew or ought to have concluded that there was no reasonable prospect that the company would avoid going into insolvent liquidation, and that person was a director of the company at the time. Thus, according to the Insolvency Act of 1986, wrongful trading refers to companies that continued to carry on their daily business trading insolvent, that is, unable to pay their debts as they fall due. It is usually a case of hoping that things will improve even though they continue to spiral downward. In wrongful trading, there is no intent to defraud the company's creditors, but merely a case of poor judgment or the failure of directors to carry out their responsibilities. The courts, in deciding whether or not a director of a company ought to have known or ascertained the company was insolvent, the conclusions which he ought to reach and the steps which he ought to have taken are those which would be known or ascertained by a reasonably diligent person, having both the general knowledge, skill, and experience that may reasonably be expected of a person carrying out the same functions as are carried out by that director in relation to the company, and the general knowledge, skill, and experience that that director has. An insolvency practitioner must apply to court to proceed with action against a director for wrongful trading. These points are not a definitive "you're guilty," and the insolvency practitioner will investigate into the affairs of the company in detail to conclude whether or not there was an offence committed. This shows why it is very important to ensure all actions taken by directors are well documented in the company records. The Company Directors Disqualification Act of 1986 identifies 3 distinct categories of conduct which may, and in some circumstances must, lead to the court to disqualify certain persons from being involved in the management of companies. General misconduct in connection with companies. This first category involves the following: a conviction for an indictable offence in connection with the promotion, formation, management, or liquidation of a company, or with the receivership or management of a company's property, per Section 2. The maximum period for disqualification under Section 2 is 5 years, where the order is made by a court of summary jurisdiction, and in 15 years in any other case. Persistent breaches of companies' legislation in relation to provisions which require any return, account, or other document to be filed with, or notice of any matter to be given to, the Registrar of Companies. Section 3 provides that a person is conclusively proved to be persistently in default where it is shown that in the 5 years ending with the date of the application, they have been adjudged guilty of 3 or more defaults. This is without prejudice to proof of persistent default in any other manner. The maximum period of disqualification under this section is 5 years. Fraud in connection with winding up. A court may make a disqualification order if, in the course of the winding up of a company, it appears that a person has been guilty of an offence for which they are liable under Section 993 of the Companies Act, that is, that they have knowingly been a party to carrying on of the business of the company, either with the intention of defrauding the company's creditors, or any other person, or for any other fraudulent purpose, or has otherwise been guilty while an officer or liquidator of the company, or receiver or manager of the property of the company, of any fraud in relation to the company or any breach of their duty as such officer, liquidator, receiver, or manager. The maximum period of disqualification under this category is 15 years. The second category covers when a company is insolvent. Disqualification of directors of companies which have become insolvent, who are found by the court to be unfit to be directors. Under Section 6, the minimum period of disqualification is 2 years, up to a maximum of 15 years. Disqualification after investigation of a company under the Companies Act 1985. Once again, the maximum period of disqualification is 15 years. The court has regard to certain particulars as laid out by the Act in order to assist the court in viewing a person's conduct as a director as unfit to be concerned in the management of a company. In addition, the courts have been given indications as to what sort of behaviour will render a person liable to be considered unfit to act as a company director. Thus, in the case of RE Lowline Electric Motors Limited, 1988, it was stated that ordinary commercial misjudgment is in itself not sufficient to justify disqualification. In the normal case, the conduct complained of must display a lack of commercial probity, although, in an extreme case of gross negligence or total incompetence, disqualification could be appropriate. The third category refers to other cases for disqualification, which can relate to participation in fraudulent or wrongful trading under Section 213 or Section 214 of the Insolvency Act, undischarged bankrupts acting as directors per Section 11 of the Company Directors Disqualification Act, and failure to pay under a County Court Administration Order per Section 11 of the Company Directors Disqualification Act. For the purposes of most of the Company Directors Disqualification Act, the court has discretion to make a disqualification order. Where, however, a person has been found to be an unfit director of an insolvent company, the court has a duty to make a disqualification order per Section 6. Anyone who acts in contravention of a disqualification order is liable to imprisonment for up to 2 years and/or a fine on conviction on indictment, or to imprisonment for up to 6 months and/or a fine not exceeding the statutory maximum on a summary conviction. In conclusion, the offence of bribery has been expanded by the Bribery Act of 2010, which can also find corporations guilty. Fraudulent trading is therefore where a company carries on a business with the intention of defrauding creditors or for any fraudulent purposes. Wrongful trading does not require intent, and this differentiates it from fraudulent trading. Wrongful trading is a less serious offence. Directors can be disqualified from any illegal wrongdoings.